How's everybody doing? It is Thursday night, June 5th. It's a Thursday. My name's Hawk. We're going to talk about a court order, a decision in this video that came out of Washington, D.C. yesterday relative to the 3 plane loads of Venezuelans who were transported to El Salvador to CECOT prison on March 15th, almost 3 months ago. But if you like this video, please click like, please leave a comment, please subscribe to my page. It's free to do so. And you know, if like another 600,000 of you guys subscribe to this page, then I can quit my job. And, you know, frankly, it's like, I mean, that would make me happy. I'm just saying that would make me happy. But, okay, so there's a judge in Washington, D.C. named James Boasberg. He is a district judge in Washington, D.C. So remember, in federal courts at the district level, that's the trial court level. The circuit court is the appellate level, and the Supreme Court is the Supreme Court. So you got 3 layers to go through. But the district judges are the trial court judges. They're the ones that hear trials. They're the ones that hold hearings where witnesses testify, where evidence is admitted, things like that. And he is... So on March 15th, that's when Trump invoked the Alien Enemies Act by saying that we were being actively invaded by the country of Venezuela and that the Venezuelan government was using the violent Venezuelan street gang Tren de Aragua to accomplish that invasion, and that street gang, members of that street gang present in the United States were operating at the direction of and on behalf of and in coordination with the government of Venezuela. A couple judges have said, yeah, that's bullshit. There's no evidence of that. And then Donald Trump's own intelligence community put out a report saying there's no intelligence information to confirm that, and that's likely false. And I think the 2 people who wrote that report were shortly thereafter fired for writing and releasing that report. So, but those planes were taken off on March 15th, and I think it was probably the ACLU, went to court on an emergency motion. They landed in the courtroom of Judge Boasberg, and his first order that he issued in this case was for the government to turn the planes around, which they did not do. And we'll talk about that more in a second here. But, and then, so he issued a nationwide injunction. I can't remember exactly what it was. It was against the Trump administration, preventing them from deporting certain people, that kind of thing. Trump appealed that on a fast track basis to the U.S. Supreme Court. The U.S. Supreme Court was like, yeah, these folks have rights to due process and habeas corpus, but they have to file those habeas writs in the jurisdictions where they're located. And they kind of took the guts, you know, they took Judge Boasberg's legs out from under him, kind of thing. And the Supreme Court also noted, it's like, you know, this is the judicial branch telling the executive branch what to do as it relates to foreign policy, foreign relations, which are the exclusive, that area of whatever is exclusively under the jurisdiction, I guess, or, you know, the control of the executive branch. And so the Supreme Court was like, you're walking a fine line here, Judge. You know, when you're essentially telling the executive branch how to conduct foreign policy, you know, you're getting a little out over the head. Excuse me. You're getting a little ahead of your skis there, is what I was trying to say. So it's been ping ponging back and forth, and today yesterday we got another ruling in the case from Judge Boasberg that initially I thought, I hadn't read the entire thing yet, and I was like, oh, this is great. because he ordered the Trump administration to provide these detainees, I think it was 238 young men, who the Trump administration abducted and secreted to this gulag of a prison in a third world country in Central America, likely for the rest of their lives. The judge ordered the Trump administration to propose a plan by which they will give these young men the due process and the habeas rights that they are entitled to. And initially I was like, that's fantastic. That's amazing. So I was looking for a good summary of this order from somebody that I trust. And of course, as I often do, I wound up on the website of Talking Points Memo. Anybody who's followed me for any significant period of time knows that I'm currently, and for the last several months, have been strongly recommending that people subscribe to 3 websites: The Bulwark, The Atlantic, and Talking Points Memo. I think that those websites are going to be absolutely critical for us normies in navigating the next 3.5 years. And I've spoken at length as to why. But Talking Points Memo has a reporter named David Kurtz, who I've been reading forever, and he's a really good columnist. And he went through this entire order and distilled it down to 5 important points that we are going to go through right now. Okay, let's dive in. So he put out, let me just read the first couple paragraphs here. After being mostly scuttled by the Supreme Court, the original Alien Enemies Act case has re-entered the conversation. While the High Court took most of the Alien Enemies Act challenges out of the hands of U.S. District Judge James Boasberg in Washington, D.C., and distributed them to the individual judicial districts where the Venezuelan nationals are being detained under the act, it left unresolved the fate of the 238-ish deportees who had already been removed to CECOT prison in El Salvador. In a significant ruling yesterday, Judge Boasberg concluded that the CECOT detainees were denied due process that they were entitled to when they were removed from the United States on March 15th. He ordered the Trump administration to propose a plan within a week for how to facilitate giving the detainees the due process, the habeas petition rights that they were denied before they were kidnapped and sent to this prison. While Donald Trump's invocation, let me read that sentence again. While convicted felon, President Donald Trump's invocation of the Alien Enemies Act was itself historic, and the cases challenging his proclamation are testing the robustness of due process. The real import of these cases is that they are where the executive branch is threatening to, and in fact is, running roughshod over the judicial branch. In defying court orders, including to, quote, facilitate the return of wrongfully deported foreign nationals like Kilmar Obrega Garcia and Andre Romero Hernandez, the Trump administration has provoked a constitutional clash, practically daring the judicial branch to try to stop it. Judge Boasberg's decision sets up another potential focal point for that constitutional clash. And let's talk about a few areas where that matters the most. So Judge Boasberg's ruling was not a complete victory for the CECOT detainees. He found it unlikely that they would win their habeas corpus claims. Habeas corpus, sometimes referred to as like the great writ, the writ of habeas corpus. It allows you to, I think it translates to release the body. And it's a constitutional right that people have who've been detained by the government to challenge the legality of their detention in government custody. for the detainees to prevail on their habeas claims, they would have to show that they are in the constructive custody of the United States, meaning under U.S. control or held at its behest. I think they meet that burden because they're being held in CECOT prison because Donald Trump asked them to and paid them $6 million to do that. That seems to me to qualify as being held at the behest of the United States or its president. It's troubling that Boasberg was unconvinced on this point, and even he seemed troubled by it. But by taking that issue off the table, he eliminates one ripe avenue of appeal available to the government. So he kind of took their legs out from them a little bit. By grounding his ruling in the Due Process Clause of the Fifth Amendment instead, he aligned with the Supreme Court's recent strong defense of due process in this actual case. And in the end, he winds up at roughly the same place because he concluded that the remedy for violating the detainees' process was to allow them the chance to pursue their habeas claims that they were denied in the first place, which is consistent with that prior Supreme Court order. Two, and this is kind of what I was talking about a little bit before. It's like he kind of is grappling with the limits of judicial power as it relates to the executive branch and the power of the executive branch. Judge Boasberg seems keenly aware that this Supreme Court is going to give maximum deference to the executive branch. Boy, that's a very diplomatically worded sentence. The author suspects that's one reason why the judge sidestepped the constructive custody issue. This court, the Roberts Court, is not going to get involved in foreign policy by ordering the Trump administrations to make demands on a foreign country, El Salvador. And so Judge Boasberg is kind of walking that fine line. He wrote the following, quote, "Although the court is mindful that such a remedy may implicate sensitive diplomatic or national security concerns within the province of the executive branch, it is also a constitutional duty to provide a remedy that will make good the wrong done." The wrong done was the denial of their due process rights, the denial of their habeas corpus rights. And so it's like, yeah, all of this stuff is kind of exclusively up to the executive branch, but we as the judicial branch have to craft some kind of remedy according to the Constitution to fix the fact that these guys were deprived of their constitutional rights. And so he's got to try to balance these two things. The bad news is that these guys aren't coming home anytime soon. In open court previously, Judge Boasberg had mused about how due process could be provided without having to return the detainees to the United States. In his written opinion, Judge Boasberg said that facilitating a return of the CECOT detainees is, quote, not necessarily, close quote, the only presumed remedy for the due process violation. I don't know how the fuck else you would do it, frankly, but that's just me. How are you going to provide them due process rights when they are still detained in CECOT prison in El Salvador, where they have no contact with family, no contact with friends, no contact with their attorneys? They're being held in a building with no windows. These guys haven't seen daylight in 3 months. They haven't been outside in 3 months. But let's try to provide them with their due process rights that they were previously denied while they're being held in that environment. What the fuck is that? No disrespect, Judge. Judge Boasberg was vague about what kind of due process he was looking for to provide the detainees with their denied due process. Quote, "Exactly what such facilitation must entail will be determined in future proceedings," he wrote. His invitation to the government to propose a process invites some sort of remote habeas proceedings. Sure, let's leave it up to the Trump administration to give a proposal as to how the Trump administration can give these guys their due process rights, the same due process rights that the Trump administration has been denying them for the last 3 months. That seems like a good plan. But in the short term, it may not matter because the Trump administration will almost certainly appeal Judge Boasberg's preliminary injunction to the D.C. Circuit Court of Appeals and ask that it pause the case so that it doesn't have to propose a plan for giving the detainees their belated due process rights before the deadline Boasberg set for next week. From there, the case is a sure bet to go to the Supreme Court again. In the meantime, the CECOT detainees, who are approaching the 3-month mark of their confinement there, will remain in indefinite custody in one of the worst fucking prisons anywhere in the Western Hemisphere. One thing that the judge did in this order is he set an injunction bond of $1, which is not typical. Plaintiffs typically must post an injunction bond, which is intended to make the defendants whole if it turns out the injunction was improperly granted at the beginning. It's common for judges to waive an injunction bond when the injunction is against the federal government. But in this case, Judge Boasberg set a nominal injunction bond of $1. And the only thing that makes sense is that, remember, in this big, beautiful bill, there is language, there is a provision which is going to get knocked out in the Senate because it's not budgetary and that doesn't fit within the reconciliation process. It'll be kicked out of the bill by the Senate parliamentarian. But they included language that said federal trial courts cannot hold Donald Trump, any member of his administration, any of his appointees, anybody in the executive branch. No federal trial court can hold those people in contempt unless there is an injunction bond that is issued and paid. Obviously, the big, beautiful bill is not law yet. It has not passed the Senate. But so I think the judge kind of did that just in an abundance of caution. And, he made the injunction bill $1 so that it can get paid. Last point, in his opinion, Judge Boasberg highlights more than once the Trump administration's poor conduct in this case from the beginning. You will recall that Judge Boasberg already found probable cause that the administration violated his court order when it proceeded with the deportations on March 14th and 15th and did not turn the planes around. He references his contempt of court inquiry in this opinion. And so he issued a verbal order from the bench, turn these fucking planes around. That is a court order, whether or not it is in writing. Then he issued a follow-up written order that did not contain that verbal admonition that he had delivered from the bench. And so the Trump administration was like, we were following Your Honor's written order. That was not in the written order. All of this serves as a good reminder that the D.C. Circuit Court of Appeals placed an administrative stay on the contempt of court inquiry more than 6 weeks ago. It's been fully briefed since April 28th, and still no ruling has issued from the appeals court. Meanwhile, several other courts have begun incipient contempt of court proceedings against the administration in other Alien Enemies Act cases and adjacent facilitate cases. It is not clear at all right now what is taking the D.C. court, the D.C. Circuit Court of Appeals, so long to issue a ruling. So we're going to be keeping an eye on this one. There's lots of stuff going on in it. And if you enjoyed this video, it was very exciting for me to make. If you enjoyed this video, please click like, leave a comment, subscribe to my page. It's free. And it is about 10 p.m. West Coast time on Thursday. That means tomorrow's Friday. The weekend is here. Please, 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 everyone, please be safe this weekend. And I will see you guys soon. I'm Hawk. Thanks for watching. Have a good night.